Objection, man.
Mr. Hensley.
I drive a BMW. Anybody with an autopilot vehicle, you know for a fact it won't do that.
Right.
That's a fact. So they don't have jurisdiction, neither do you.
All right. And he pulls his gun. And guess what they did? They shot each other. And they both died. So, Mr. Hensley, here we are again today, sir. First, I want to start with this. When I arraigned you a couple weeks ago, you were given the opportunity to request court-appointed counsel, and you were also given the opportunity for the last several months to retain your own counsel. Are you representing yourself today, sir?
For objection, for the record, let the record reflect. My appellation is Malik, title is Big. Works American National under Islam.
Anything else?
Proper persona sui juris.
All right. So, sir, the information that I have in front of me has your listed name as Milton Joseph Hensley Jr. So we've been through this before. Respectfully, I'm going to call you by the name that is listed in the information, Mr. Hensley. So, Mr. Hensley, do you wish to proceed by representing yourself today, sir?
Over my Fifth Amendment right.
All right. You don't wish to answer any questions from the court?
Over my Fifth Amendment right.
All right. So you're not going to answer the court when I'm asking, do you wish to proceed representing yourself today for circuit court sentencing? Do you wish to do that, Mr. Hensley?
Objection. My appellation is Malik, title is Big.
All right. So then let's get this on the record. As far as the PSI, Miss Bond, it would appear that the court has a copy of this. Mr. Butler apparently has it. And then what do you know about Mr. Hensley receiving this copy? So Mr. Hensley, have you had a chance to review the pre-sentence report, sir?
Objection. My appellation is Malik, title is Big. And for the record, you have my nationality information within your files. So you know my appellation.
A hearing, if you will, that would require and entitle, I should say, the defendant to the assistance of an attorney, which is why I'm asking. However, the court is balancing that with the idea that this circuit court sentencing date has been delayed several times, and the court can't help but glean at this point it just appears to be a delay tactic. The court, we sift that back through the dates, has given Mr. Hensley several times to hire counsel. He expressed that interest. Again, it appears in hindsight that it's simply a delay tactic.
Your Honor, I apologize for not being here in person today, but I could not find the time again to keep seeing this through. The amount of stress and anxiety Mr. Hensley has caused my family is downright disgusting and infuriating. Pull a gun on a family driving down the highway for nothing more than getting out of his way, not getting out of his way fast enough is obscene. My daughter, who was only 9 years old at the time with special needs, was terrified, and it took months for her to feel comfortable riding in any vehicle again because she was scared someone was going to cut her life short for seemingly no reason at all. My wife had to start and is still in therapy over this whole situation, which has thankfully helped her anxiety levels to become manageable, but also is not covered under our insurance. So it's cost us quite a large sum of money, and that brings with it its own stresses to our family and social life.
I object to that.
Hold on. So, Mr. Hensley, what is your objection?
Tell him prove everything he's saying. If his wife and everybody went through the trauma, show me the doctor bill and report that he went through it. Because I can't believe somebody that was slamming the brakes on the interstate at 75, 80 miles per hour deal with trauma. You could have killed us and everything behind me. Ain't no such thing as you got trauma for you slamming your brakes.
All right.
Prove the accusation that is made. Prove it.
All right. So, sir, I am going to bring
the script like you coming from a movie or something.
As expressed in that statement that was just read into the record, how this is still affecting the minor child. And that makes sense in court as it relates to somebody that's 9 years old and was observing somebody pull up next to them and point a handgun at them.
Still haven't been proven for the record.
Mr. Hensley, you've been convicted of that, sir, by the court.
We're gonna have all that. We will have all that.
So please let me finish, and then I certainly will give you the opportunity to address the court before sentencing. All right. So, Mr. Hensley, I'm going to give you the opportunity before I ask you to address the court for sentencing. Do you have any additions, corrections, or deletions as it relates to the pre-sentence report?
Yeah.
Do you have any additions, corrections, or deletions?
All those accusations are false, and none of them have been proven.
Okay.
Not one. And he talking with this story.
As it relates to this report, do you have any
I don't have
additions,
no report.
corrections, or deletions? Excuse me?
No, I don't have no report.
All right. So, as it relates to sentencing, is there anything that you want to state to the court before a sentence is imposed?
You know, I have my medical information. You know, I have stage 3 cancer. You know, I have head trauma. You know, I have a neck and back injury and something with a dry foot. For the record.
Anything else then, Mr.? All right. How close Mr. Hensley and his vehicle were to them to the point they were extremely uncomfortable?
Objection.
Did not, hold on, Mr. Hensley, let the court finish. Okay. To the point that they thought they were going to be struck. The victim, I recall, describing being unable to even see the front of Mr. Hensley's vehicle. That's how close it was, meaning the grill, headlights. I recall the testimony. And that they immediately got over. Now, all of that, I think, is certainly actions that would cause the victims here to feel their life was in danger if somebody points a gun at them. The fact that somebody is tailgating back closely behind them on the highway at speeds of 70, 75, 80 certainly puts people in danger, could cause people to be incredibly uncomfortable about what's going to happen next. But it's a long way, Mr. Hensley, the court saying, having sat through the trial, you create the situation by driving in a manner that makes these folks uncomfortable, by coming up on them at a high rate of speed and following them that closely.
Objection, man.
Mr. Hensley.
I drive a BMW. Anybody with an autopilot vehicle, you know for a fact it won't do that.
Right.
That's a fact.
So, Mr. Hensley.
Not what he giving you on out of his mouth. A fact. An automobile will not get up on nobody automatically jam brakes. I told you BMW does that.
The trial is over. You had an opportunity to cross-examine those witnesses.
I did that, and you deleted everything I said.
Yeah, court
and you heard everything that they said was a lie.
So now
and you know it was a lie.
Let the court finish. All right. So the testimony was as the court has described, and there is no doubt that all of those actions Mr. Hensley is responsible for. Where Mr. Hensley is right on the bumper of a young lady, Grand Rapids, Kent County area, and then when she is very uncomfortable and pulls over and stops, Mr. Hensley again introduces a gun, pointing it at that individual. Now, I mention this because I'm not using that as it relates to a sentencing issue. I'm using that, and that it's clear Mr. Hensley drives in a manner that endangers other people, that causes them to report his activity to other people, and then when they attempt to evade, if you will, what Mr. Hensley has caused, then he introduces a gun to the situation. Now, Mr. Hensley, I don't have to tell you that it's fairly obvious that in today's world, right, today's world of shall issue CPLs, that even if you believe that somehow you're justified in displaying a weapon, and for the record, there's nothing in this trial, nothing this court heard with the 404B evidence or the incident at hand here that we're sentencing you on that would suggest that in any way, shape, or form that you were not responsible, that you had any legal justification to introduce a weapon to it. But even assuming in your own mind that you were, what happens with that in today's world is they would have a very easy avenue to articulate, I felt in fear for my life or great bodily harm, and assuming they were lawfully carrying a gun, could take action, shoot you, in other words. And I can remember just in little Ione County, an incident that occurred just a few blocks from here, in which an individual was tailgating a lawful CPL holder going right down Steel Street over here. And so that individual, much like here, got over, pulled into the car wash to get away from this guy. And the guy behind him pulls right in behind him, much like in the 404B evidence I heard with you. And so what happens is the CPL holder, what is this guy doing? He's crazy. He pulls his gun. Now, you can argue whether he could articulate at that time whether he felt his life was in danger of death or great bodily harm. But regardless, so what happens is the tailgater, he then also was a valid CPL holder, and he pulls his gun. And guess what they did? They shot each other, and they both died. And what the court likes to do, Mr. Hensley, as I'm reviewing this, I will say this, I'm weighing positively in a positive manner here. You stand before the court at age 50, you don't have any prior criminal history.
Exactly.
Which is somewhat remarkable when I heard about the 404B evidence. So
Exactly.
I don't know how that didn't result in some sort of crime, but it didn't. And I'm recognizing that, and I'm going to recognize that in the sentence I'm going to impose here in a minute. We do have the sentencing guideline now, which is 5 to 23 months. Court likes to think about the middle. The middle of 5 to 23 is going to be 14. And I also want to recognize that you don't have any prior criminal history, and that I will also recognize until lately that you've been cooperative with the court. You showed up to court, that you, as far as I could tell, did your very best to represent yourself, and were adamant about doing so and took this matter seriously. All of those things, I think, are things the court can weigh that are positive to you. The negative, though, sir, is the outcome of this is your actions and one causing this and then making it worse with introducing the gun and pointing it at this family on the date in question.
Can they prove that?
They did prove that.
No, they
Beyond
did
a
not.
reasonable doubt
No, they
at
did
trial.
not.
I recognize you disagree with that.
Because you had
asked the court to
you
decide
had
it,
photos,
and
you
the
had
court
video,
decided it.
you had somebody's mouth.
Those are all
Yes.
evidentiary issues that you, again, can explore on appellate review, sir. You're welcome to do that.
Yes.
All right. So as it relates to the carrying a concealed weapon, all right, so carrying the concealed weapon is count or charge number 1. Court's going to impose a sentence of 12 months to 5 years. That's under the minimum guideline range of, or the middle, I should say, of what the court was looking at 14 months. So it'll be 1 year to 5 years with the Michigan Department of Corrections, and you do have credit now for 14 days that you have previously served. As it relates to the felonious assault, now this would be charge number 2. The court's going to impose a sentence of 1 year with the Michigan Department of Corrections to the statutory max of 4 years. You will receive credit for 14 days that you have previously served. And then as it relates to count 3, this is the felony firearm. The court is required, Mr. Hensley, to impose a sentence of 2 years with the Michigan Department of Corrections. And then counts 1 and 2 that I mentioned earlier will be served concurrently with each other, but this count 3 by statute is required to be served consecutive with and preceding these other 2 counts. So 2 years with the Michigan Department of Corrections. As it relates to the monetary obligations, Mr. Hensley, the court is required by statute to impose $130 as a crime victim rights assessment. Court's going to impose court costs in the amount of $1,500. There'll be a $60 DNA testing fee, and then required by statute are the state costs in the amount of $68 on count 1, $68 on 2, and $68 on 3. All right, so Mr. Hensley, you do have a right, and this is something you're interested in. You've expressed that interest to seek appellate review of the sentence the court has imposed. If you'd like to do that, you have 21 days from today's date to make that request. You have the appellate paperwork there.
They're ready for him along with the pen.
All right.
He's already in the district court. You want the case number?
So hold on. So you have 21 days from today's date to make that request. So if you can, then there's a pen there. I need you to sign. There's 2 copies of that. One for you to keep, the other one for you to initial and date that you've received it. So if you could do that for me, sir, it's right there on the podium. This is your all rights.
You can take that with you. I'm not signing anything.
All right, so for the record, Mr. Hensley Bay is indicating you don't want to sign that, sir?
I'm not signing anything.
All right, so for the record then, Bill, I am going to send back with the deputy his copy of the appellate review form. I'm going to place the unsigned appellate review form here. Mr. Hensley, only because we've dealt with this case for so long, if you want to explore these though, this form is important to you, okay? I recognize that you are refusing to sign it or acknowledge it for the record, but this is something that you want to file timely if you want appellate review of this.
They don't have jurisdiction. So they don't have jurisdiction, neither do he.
All right. Well, I think that the court has jurisdiction.